Professor John Zeleznikow is a professor of law and technology at La Trobe University of Law School in Bandura, Australia. Prior to this position, he was a professor of information systems at the Victoria University Business School and director of the Joseph Pell Centre for Forensic Statistics and Legal Reasoning at the University of Edinburgh Law School. He has conducted research for 50 years in Australia, USA, France, Netherlands, Israel, Scotland, Spain, Poland, and Estonia. He has received over 8 million Australian dollars in research grants from the Australian Research Council, European Union, Scottish Higher Education Funding Authority, French Scientific Council, and Dutch Scientific Council. 20 of his PhD students have graduated. We are very honored to have Professor John today, and he'll be giving a talk on online dispute resolution using artificial intelligence to enhance access to justice. So I request a big round of applause for Professor John here. And over to you, Professor. And I request you to please share your screen so that you can continue.
Oh. Okay. Here we that should be right now. Well, good morning, good afternoon, or good evening, whoever I'm talking to in the world. What I would like to speak to you today is about using artificial intelligence in the justice field, particularly with regard to online dispute resolution and to support non-professionals. For the last 6 months, I have been working, doing research at the law school at the University of Granada. And to me, it's been a fascinating experience, first of all, because I'm in a different legal system, one of civil law, not common law, and two, because in Spain, everybody who goes to court is represented by a lawyer. But this is not the case in Australia, in the United States, Canada, and the United Kingdom. So what I'm going to be wanting to talk about is tools for the whole of the legal community, including people who are not legal professionals. And I should stress that a lot of this work is with Amy Schmitz, who's at Ohio State University, and you can see the article that I've referenced on the front page. Now, since the 1970s, there's been a growing trend to seek alternatives to litigation. Litigation is slow, it's expensive. Mark Galanter at University of Wisconsin in Madison concludes that in the USA, the number of trials is shrinking, which seems surprising because everything else is growing. So meanwhile, many, if not most people in need of legal redress can't afford lawyers. So they go to court by themselves. These people are called pro se or self-represented litigants. And the problem is these litigants lack the resources to adequately represent themselves, and they're disadvantaged in court. Not only are they disadvantaged in court, but they severely hamper the court system. And at the same time as this rise in self-represented litigants, we have had the development of online dispute resolution, which, as you'll see, is essentially the use of information technology in alternative dispute resolution. And online dispute resolution can be particularly helpful for self-represented litigants, since you don't need a lawyer's assistance to use a lot of these tools. And we argue that, in fact, the legal technology community needs to go further in developing and providing low-cost tools for self-represented litigants and other justice users to enjoy greater access to justice. Okay, So what is online dispute resolution? It can be using the internet to perform alternative dispute resolution and other things. But what it is, and this is the thing that I am always trying to convince legal professionals of, it is far more than video conferencing. Video conferencing is an important part of online dispute resolution, but it is not everything. Now, the pioneers of online dispute resolution really saw of it as a futuristic idea, and in the very early days, it was only about resolving e-commerce disputes. And of course, with the growth of e-commerce, it became incredibly large, and Colin Rule paper was talking about 60 million disputes a year. But up until 2010, there were a lot of research papers, but very few practical systems and none outside e-commerce. But things are changing. And I'll be talking about how they're changing, and even more importantly, how they should change in the future. Why use online dispute resolution? Well, it's efficient. And that's particularly important for low value, high volume transactional disputes. It is accepted amongst key stakeholders. Of course, online dispute resolution is much cheaper than going to trial, and of course, much quicker. All of those major benefits. And the example that Colin Rule talks about, but it's a very pertinent one, is an eBay user purchasing a Madonna CD left unsatisfied. How are you going to try and do it in a face-to-face dispute? Are you going to go to court? Who do you go to court with? Where do you go to court? I mean, I find my children, particularly during the pandemic, the dog got excited because the only person visiting was the postman with, in fact, purchases bought on eBay. Younger people really love using eBay, but how do they resolve disputes formed by those purchases? I think it's very useful to have a history of ODR and ADR, because in fact, if you want to know where we're going in the future, you need to understand the past. And I start the past in the 1970s, where you had the Pound Conference in the United States in 1976, and the publication of Fisher and Urey's Getting the Yes book. You have the Harvard program on negotiation starting. So the first movements towards a formal alternative dispute resolution system. At the same time, and a bit later, you get expert systems, generally being rule-based, so quite simplistic, that model legalistic decision-making. Two examples are Taxman of Vaughan McCarthy at Rutgers and the Latent Damage Advisor by Capper and Susskind. And of course, everyone knows Richard Susskind, but he did build an expert system for latent damage advice as his PhD at Oxford. 1990, you got the internet. And a few years later, you got e-commerce because of disputes over the internet. And in the decade of 2010, you got the development of practical, usable systems, and we'll talk a little about them beyond just e-commerce. The Rechtwijzer system in the Netherlands, which has not been that commercially successful and has had to be readapted, and the British Columbia Civil Resolution Tribunal, which is probably the most outstanding use currently of online dispute resolution. And if you want to see more work on online dispute resolution for non-financial disputes, see the book of Ethan Katch and Orna Rabinovich-Aini, Digital Justice, Technology in the Net on Disputes, and see the Access to Justice work at Kent Law School. So One of the very important points to be made when you're trying to build online dispute resolution systems for non-professionals is that it's got to be user-centric. It's got to be able to be used by the user. And there are systems for debt, for employment, and for family relationships for people using them without professional help. And so they've got to be user-friendly. And human-centered design focuses on users' experiences to develop solutions that are both experimental and iterative. Now, Margaret Haven at Stanford Law School identifies 7 key recommendations for courts and self-help centres to improve efficiency and usability. If I had more time, I would talk about her recommendations, but sadly I don't. So you can go and read Margaret's paper. Richard Susskind says, and no talk on online dispute resolution would be complete with that, talking about Richard's work. Richard talks about 2 tiers of online courts. The first uses a rule-based and case-based systems. And the ones I mentioned a minute or 2 ago, Rectvisor and the British Columbia Civil Resolution Tribunal, and almost all compliance systems such as Robodebt and driving regulations use rule-based and case-based systems. They're older systems, but they're the ones that work. The second tier, maybe what people today think of artificial intelligence, is using a machine learning system helping parties by predicting the likely outcome of their case were it to come before a human judge. And I'm going to talk about our system, the split-up system, which advises upon the distribution of marital property following divorce in Australia by providing appropriate BATNAs. So telling you what would happen if a dispute were likely to go to court. These systems are far newer, present far more problems, but also can be very, very useful. And Roberge and Fraser argued that an optimal platform from a commercial standpoint will provide guides and flow charts, question and answer interfaces, transparent ethical commitments, outcome predictions, an expedited procedure leading to an enforceable outcome, a proportional cost model, a mediation process, and a range of communications. I'm going to talk on how we might extend what Roberge and Fraser argued. Now, machine learning today, and I think it's a bit of a problem. Today, when people think of artificial intelligence, they think of machine learning, they think of robots learning and doing things. Well, that's not the case. The most used and useful systems have in fact been what I'd call the first generation of artificial intelligence, rule-based reasoning and case-based reasoning. But machine learning is exciting. It's all the rage at the moment. So let's talk about it. Raj Kumar and others argued that a central challenge in building a machine learning model is assembling a representative, diverse data set. And what I'd like to argue is that this is possible in medicine. You know a person's height, you know a person's weight, you know their blood pressure. Much more difficult in law because the data is not clean and there isn't as much data. So the point to make is machine learning in law won't model its use in medicine or in finance. If you're looking for an area of law where machine learning could be useful, it might be in the legal domain, in the family law domain, but particularly about property distribution following separation, less so when you're talking about the welfare of children. What happens with family law is there's more data and most clients can't afford expensive, time-consuming litigation because they can't wait 3 years to have an answer. Now I want to talk about certain systems, because what I'm trying to do is to build a model for you of how to use AI in online dispute resolution. And I want this model to be far more than just video conferencing. So almost the first sort of system I want to talk about is one built by Carl Branting when he was at the US Supreme Court as a research fellow with the Idaho Supreme Court Technology Committee, and this was in 2000. And they looked at a number of different areas, including sentencing, pretrial release, child support in family issues, and protection orders. They chose protection orders because they thought there was a real need there to help people who were being abused, because in America, and I must say that's different to Australia, in America, judges can't help abused women. They sort of say, well, because we have to make a decision, we can't give you advice. So at least they felt that, in fact, by building computer systems, you could help people who were fleeing abuse. And so it relieved court staff of the painful choice between providing unauthorized legal advice and ignoring the needs of domestic violence victims. Now, in Australia, this is not a problem because you would provide legal advice to people suffering domestic violence, but in the US, you couldn't. So Carl Branting's work was very early use of such a system. Now, I'm going to discuss a variety, Branting's work being the first, of systems that use AI to support online dispute resolutions and to develop a methodology. Now, the really useful AI systems are rule-based systems or case-based, with an aim towards eventually including machine learning. The first system I want to talk about is the British Columbia Civil Resolution Tribunal. And it had its goal to be timely, flexible, accessible, affordable, and efficient. Okay? So less about the actual principles of justice and legal argumentation, but being practical. It diagnoses the dispute presented to the Civil Resolution Tribunal and provides legal information and tools such as letter templates. Simple, but very important. If the initial provision of advice through the Rule-Based Solution Explorer, which essentially gives advice about BATNAs and bargaining in the shadow of the law, it does not resolve the conflict, applicants can then use the Civil Resolution Tribunal to support dispute resolution. So you support the application, and disputants can enter a secure and confidential negotiation platform where they attempt, without external help, to resolve a dispute. So using negotiation is two-person negotiation. If the action fails, then you can get a facilitator or a mediator. If you get agreements, they can be turned into enforceable orders. If mediation, negotiation, or facilitation don't work, then you can get an independent member of the Civil Resolution Tribunal to make a ruling. So going through to getting a judicial decision. Now, when I wrote the paper about 2 years ago, the British Columbia Civil Resolution Tribunal dealt with the following 5 cases, categories of cases. They now, in fact, go far further than just these 5 categories. For housing disputes, and I must say, I'll stick to Canadian dollars in values because I'm speaking to a global audience. Previously, I spoke in Europe, so I also added euros. So for housing disputes, up to $5,000, which is not a lot. Motor injuries up to $50,000, which seems to be a lot, but it's not really if you've had a nasty motor injury. Owners corporation, which you can also call strata titles or condominiums, any amount. Small claims up to $5,000, and cooperative associations and societies, any amount. But they've now moved into, because I was speaking to some people a few weeks ago, into a lot of neighbourhood disputes. Now, for these 5 domains, this is the really critical factor. Potential litigants are restricted to only, and the key word is only, using the Civil Resolution Tribunal. Paper-based solutions are unavailable. And I know a lot of people say this is unjust, it's unfair. What happens if people can't cope? And it can lead to major problems for the digitally disadvantaged. Fortunately, as time goes by, the digitally disadvantaged become fewer and fewer. To deal with this dilemma, potential litigants can receive assistance in accessing the internet. So the interesting thing is, in Australia, in Canada, USA, United Kingdom, there is legal aid to support people with legal disputes. Now, but the trouble is that costs lots of money. Governments are not keen to spend that money. So we're doing, people are being pushed to do it by themselves and to do it online. If they're facing difficulties online, then the help is to help them online rather than to provide legal advice. Now, we believe that the major reason for the significant success of the Civil Resolution Tribunal is that the British Columbia government has decreed that the Civil Resolution Tribunal is the only forum in which residents can attempt to resolve those disputes listed above. So you've got no choice. You've got to go online if you want to deal with issues only dealt with by the Civil Resolution Tribunal. Okay, and that is a very different story to Rechtwijzer, which is a Dutch platform for separating couples. And again, the idea is to help citizens do it themselves. Couples started off paying €100 for access. And the system will do what a traditional, almost mediation system does. It'll ask each partner for data, such as age, education, income, what they want to achieve. The Rechtwijzer system has a diagnosis phase and intake phases for both parties. Following the intake process, the parties are encouraged to commence working on agreements of those issues that occur in every separation. And they will include how to communicate, child welfare, property. Property is not just housing and money, but also debts, and child support and spousal maintenance. Now, Rechtwijzer uses focusing upon the children and parents' interests rather than haggling about rights, so integrative negotiation. But ex-partners are formed of relevant processes with regard to dividing property, child support, and standard arrangements for visiting. Final agreements are reviewed by an independent lawyer. If the couple can't agree using the Rechtwijzer system, then by themselves they go to a mediator. And of course, that costs extra money, €360, or if they ask for a binding decision, they can ask for an adjudicator. Up until you get the adjudicator, use of the Rechtwijzer system is voluntary and non-binding, but of course, with the use of an adjudicator, it needs to be binding. Now, the initial goal of the Rechtwijzer developers, and remember, in British Columbia, it was essentially the government who developed the system. In the Netherlands, the government supported it, but it was a private, not-for-profit Rechtwijzer system. Their goal was to be self-financing, primarily through user contributions. Well, unfortunately, it was not self-financing, primarily for commercial reasons, unrelated to the quality of the system, and the Rechtwijzer people have changed what they're doing, and having chatted to them, they feel more optimistic now. Now, the next issue that I want to talk about, you might wonder why, and it's not really artificial intelligence, but it is much more similar to what I talked about with Branting's system, is domestic and family violence that's used as a part of a triaging systems to ensure timely action to protect potential victims. So I'm talking about triaging, I'm talking about urgency. You know, the trouble with legal systems is they haven't been urgent, and when there's domestic and family violence, there's a need for urgency. So ODR systems need to triage. They should build in tripwires based on answers to questions or evidence gathered through maybe a GPS to observe that one party is being stalked by another. It's not only domestic violence, it's cases of child abduction or the granting of bail when there needs to be immediate access. So it's important for triaging to be available to initiate and expedite action in high-risk cases. So timely, relevant advice is vital. And you'll see why I'm raising this in the future. Now, some peer systems in the family domain. Co-parenter helps separated, divorced, and never married parents, but it doesn't really tell you what to do. It helps you manage co-parenting responsibilities. It creates court-ready plans, and it helps resolve disputes, and it ensures that the parents are child-centric, right, rather than wanting to get he says, she says arguments about parental rights. Integrated ODR facilities have negotiation and mediation. And the main thing is communication, secure timestamp measuring, records of exchanges. It's a rule-based system, so quite simple, but very valuable in helping parents not so much reach decisions, but actually communicate and cooperate with each other. Now, a system that's very different, and I have an interesting video, but if I had an hour and a half or 2 hours, I would show it, but I don't, is the system we built in the 1990s called Split Up. And it's a predictive algorithm used to determine a partner's BATNA. It used 103 cases to look at how future assets could be divided. Couples put in, and they put in data, costs, labour, division of household duties, although you can have arguments about data, as has been pointed out, and that's a very an issue we need to look at. Future job prospects. Despite using AI, the system involved a lot of conceptual modelling. We really had to understand the domain. We spoke to our domain experts at Legal Aid and the Family Court. Now, 25 years later, the theoretical principles behind AI software has not changed. And this is the thing to tell people, particularly people who are not computer scientists. AI principles, AI software haven't changed. It's the same software as 25 years ago. It is much more efficient because both software and hardware are less expensive. Data can be much more easily stored, and more data can be stored. And so the software is faster and hence can be more useful. Portable and the Legal Services Commission of South Australia have designed and developed a new system called Annika, which is being used by Australian family lawyers, very similar to Split Up. Now, our Family Wizard is a tool that is very used in the United States. If I had to talk about 2 very heavily used tools in US courts, they're our Family Wizard for family law and Compass for sentencing. And Compass has been very controversial because people argue that it's very biased against certain groups of people, particularly African-American men. But our family wizard, like co-parenter, offers tools to parents for scheduling, tracking, reimbursement requests, communication, and creating logs of communication. It emphasises effective communication. It allows parents to create third-party accounts for others to be involved, such as their therapists. The app offers case management, the ability to view a client activity, and access to easily downloadable client records. But almost the major thing is that our family wizard does a trace of the way the parents communicate with each other. And so judges often look at the Our Family record traces to predict which parents are being reasonable and which parents are being unreasonable. Now, another system I've personally been involved in was called Family Winner. And again, there's a video if you want to look at it. And it uses game theory as developed by John Nash to help the mediation process and give parties an idea of trade-offs. Can be used in other disputes, but we used it in family. The systems ask if the issues can be resolved in the map's current form, and if users are not happy, they break down the issues and they give their priorities. So Family Winner helps you do trade-offs, and it helps meet users' priorities. It's not just justice-centered as is split up, but it is user-centered and giving people the priorities they really want. And I talk a bit more about two other systems which were not in the family domain, Adjusted Winner and Smart Settle, which are very much about trying to provide users with trade-offs and give them the best solution that they want. The final thing I want to talk about are agreement technologies. And agreement technologies come very much from the area of automated negotiation. And there are a lot of people in computer science, less in law, who do automated negotiation. So agreement technologies are computer systems in which automated negotiation agents act with each other with the idea of reaching a mutual agreement. So their idea is to, in fact, have people agree and to provide software to help people agree. And one of the interesting things I've been told, particularly with telephone dispute resolution, which is very successful, but when the mediator then sends a parenting plan to the parents, parents say, we can't agree. So they have an in-principle agreement, but they are having difficulty drafting the in-principle agreement for a practical agreement. And that is what agreement technologies will hopefully help with. Now, I have some overheads on COVID-19. I won't go too much into it. Fortunately, we are going back to face-to-face work. But the point about it is COVID-19 was predictable, and certainly Bill Gates had talked about it in 2015. The problem was that until we really needed technology to help with courts, because people couldn't meet face-to-face, we ignored the problem. So we could have built systems, virtual systems, to help with what tended to be the problem with ODR. We didn't. And many criminal jurisdictions had to adjourn jury trials and just about the future in public hearings. We're now into that future, but we are developing ODR tools. So what I've done, and now I'm trying to get you to a model. We've examined ODR tools that somehow incorporate data analytics, algorithms, and ADR. And we believe that a truly helpful and holistic ODR program, particularly to assist self-representative litigants, and other non-professionals should have the capacity to provide the following 6 processes. Part of a modular system, not every dispute will require all 6, but they are necessary. And so let's now talk about it. And in fact, the 6 things I'll talk about are case management, triaging, advisory tools, communications, design support, and drafting software. And once I've introduced these ideas, I will go back, or Amy and I will go back and measure how current systems are doing. Okay, so case management. The ODR system should allow users to initiate the dispute and provide templates to enter information. So they also ought to be able to query users for appropriate data, or to be able to initiate the conflict, access data, and be aware. Okay, they shouldn't have to phone their lawyers or other professionals to find out what's going on. And self-represented litigants have a limited knowledge of legal processes and procedures. Providing them with case management tools is very important, so they know what information is required and when. Okay, triaging. And this is where the domestic abuse and other issues come in important. The ODR system should indicate which cases require immediate action and which cases provide less risk to litigants and can afford to be delayed. I mean, if you go to a hospital, you're immediately triaged and the most urgent cases are heard first, are dealt with first. Why not the same in law? Non-professionals also have difficulty in choosing the appropriate forum for their dispute. Where do you go? What courts deal with what issues? Their triaging can help. The ODR system should suggest immediate interventions where necessary and otherwise direct parties where the cases should be addressed and or heard. So they're vital for initiating and expediting action in high-risk cases. The significance is especially vital, as I said, with bail, child abduction, domestic violence. So they're really necessary for at-risk individuals. Now, the third thing, and this is why I talked about my split-up system, but it's not the only one, and it's advisory tools. The ODR system should provide processes for reality testing. You know, I have certain goals I want when I go to a negotiation. Are they realistic? Is it useful? So a BATNA advisory system like Split Up, useful parenting advice, calculators such as tax advice, child support obligations. You could add legislation, reports of cases, videos of desirable, and even more importantly, undesirable behaviour. When you see undesirable action in other people, maybe you won't do it yourself. These sort of advisory tools assist the disputants to enter the mediation negotiation with likely and best outcomes. And they're particularly vital for people who don't know the domain. The only problem, and as I've said with user-centric information, is even if you build subsystems, will they be useful for self-represented litigants or anyone who hasn't got legal advice? Are the legal concepts too difficult for people to understand, like paramount interest of their children? How do you construct suitable user interfaces? Lots of research work is still required, but we need to provide such advice. Okay, 4 is the one you'll all agree with. Now, all current ODR systems provide communication to support a combination of arbitration, conciliation and facilitation, mediation and negotiation. And these tools also can provide a shuttle mediation. They can be very effective where there are toxic relationships, which make it difficult for parties to reach agreement while in the same room. And they can also be useful for providing a trace of the parties' action in disputes so you understand what is really going on. Our family wizard does it. So communications is our fourth step. The fifth is decision support tools. Often you receive advice about the process, what's likely to happen, what would be a likely outcome if you go to court. But the real problem then becomes is, how can you agree? You know, how do you, if two parties are in conflict, how can you reach a resolution which most gainfully meets both of their needs? And I showed you talked about our founding winner. You can use AIs or algorithms on game theory to facilitate trade-offs. Whilst professionals can provide significant advice regarding trade-offs, ODR systems, particularly with mathematical decision support tools, can really help using advanced analytics. So they can provide each disputant separately with advice about appropriate options and likely outcomes. And particularly self-represented litigants have limited experience in negotiation and scarce skills, so that'd be very useful. Plus, being involved in a conflict where you have no professional help is very stressful, and when you're under stress, you don't make good decisions. So useful to have advice. Now, the final step, and you'd think we're there if you've agreed with the analytical tools on decisions on doing trade-offs. But once the parties to a dispute reach an in-principle agreement, now you've got to get the in-practice agreement. And computer software can help in drafting acceptable agreements. Having technologies available to memorialize an agreement saves everyone time and stress. And it's problematic when parties back away from a concluded agreement under the guise of falsely claimed lack of memory. So if you can immediately, in an online dispute resolution, get an agreement, get the parties to sign, that is great. If you've got software to help you draw up that agreement quickly, even better. I suppose people talk about ChatGPT. I hadn't considered that, but in fact, once you agree, you want drafting software. So preparing agreements such as parenting plans that are acceptable to all parties is a complex task that is especially problematic for parties without expert support. So we're proposing further development of free or low-cost access to these 6 modules. This is an aspiration. It's where we should be going rather than where we are at. Okay, now the final thing I want to do, and looking at my telephone, I see I have about 10 minutes and I want to allow people some questions as well, is we've proposed such a model. How does it fit in with current reality? So we took, I think it was about 60, 64, checking the papers, self-reported ODR providers from the US National Center for Technology and Dispute Resolution, some ODR systems behind paywalls, so we couldn't access them. But we believe we have a good cross-representation of ODR systems. And as you can see, 55 of them had communication tools, 46 case management, but then very little of the others. 21 advisory tools, which is about a third, and the rest for triaging, decision support, and drafting, almost none. So, you know, and I'll go back to this, and this is a real problem, okay? Communication you'd accept, and we all know that. And that's what most people think of when they think of ODR, they think of communication. But if you're going to build technology, if you're going to use technology and computer tools, you can do more. Case management, okay, but the rest very valuable, they're not being done. Half of them did mediation, a third arbitration, and less than a third negotiation or settlement conferences. So now, analysing this approach. We didn't include Zoom or Teams as ODR providers. They let you talk, but they don't. They're for anything, they don't do ODR. The analysis of providers also highlights the focus on communication-oriented processes. Everyone's been talking about communication. And I suppose with communication, one of the major things you're concerned about is security. And, you know, most of the providers, I know they're worrying about security communication. Triaging, decision support and agreement technology is very rare. But self-represented litigants need triaging. If you're fleeing domestic abuse, triaging is the most important. It's only once you get into a dispute, then you need some help with decision support. And if you can reach an agreement, drafting. And if you don't have these tools, then you're very much disadvantaged. So we need, really would be nice to have all-inclusive ODR systems. They're very rare. So what we're saying is there's real need for these systems. There's not enough attention paid to dispute system design, particularly for people with access to justice needs. The point is the legal system is moving well beyond only having lawyers. You need human user-centric advice. All 6 typographies should be available in a modular way. Such development must be abide by ethical guidelines, including vigilance regarding the use of AI and algorithms to ensure that people don't get second-class justice. And you know, sometimes if you worry too much about efficiency and effectiveness, you may give people second-class justice. So we need to reimagine access to justice through such an innovative approach. Thank you very much. Now I need to, what have I done? I need to stop.
Thank you, Professor Zeleznikow, for a wonderful talk. So we have around 5 to 6 minutes for taking questions. So are there any questions?
I've got to stop share.
So, like I've just one small question. Like you mentioned that the system design must be human.
Yeah.
Like, can you throw some light on?
No. I didn't use the word human. I think I used the word human-centric. Okay, which is different. Human-centric means that it's got to be supportive of humans. It's got to be easy for humans to use. It's got to have good interfaces. It's got to use words that, in fact, and technology that make it easy to use. That's what I mean.
Okay, thanks.
Hello, Professor. So I have a question. So these systems are meant to resolve disputes between 2 or maybe 2 parties. So the issues that they discuss, they are that's very private information. So how do these systems manage the privacy? So when you're considering learning models that take data from existing dispute resolving systems and learn some predictive technique, so how is the privacy issue handled in such cases?
Well, there would be a database of previous cases. For example, if you're doing predictive analytics, okay, then you actually do the predictive analytics on decided cases, right? And the predictive analytics, the decided cases are all in court judgments. I suppose when you go to court, you lose your right to privacy. If you're talking about, you know, and that is the only time that you're using machine learning. Most of the tools don't use machine learning. And so they're not using data, they're using expert opinion and processes. And so privacy is not a problem when you're using predictive systems, because, as I said, they are court cases, then you don't expect that privacy.
Okay, thank you. So I think we have come to the end of our session. I want to thank Professor Zeleznikow for such a wonderful presentation and also the participants. So I hand over to Professor Saptarshi Ghosh.
So thanks, Pragya, for chairing the session. Yeah, so Professor Zeleznikow, thanks a lot for your talk.
It's a pleasure
Okay.
to give it. I gave you my overheads, and there is a recording.
Yes.
So if anybody, I'm delighted to chat with people. Love doing research, delighted to chat to people. So if anyone wants to be in touch with me, I've given you my email. That's the best way to contact me, because I've been at the University of Granada for the last 6 months. You have my Spanish phone number. That will be changing in a few days' time.
Okay, great. And yeah, so I hope it's okay if we share those overheads or slides with the audience.
Yeah, not only is it okay, I would like you to do that.
Great.
Because I'm very keen to move forward with some of the ideas that I've been suggesting, and the only way to move forward is to collaborate.
Sorry?
The only way to move forward is to collaborate with people
Sure.
around
Yeah,
the world.
of course.
And just looking at the names, I see that you have people who've logged in today around the world.
Yeah, we try to. Yeah. Okay, thanks a lot. So we will close the session now. So thanks a lot to the online audience also. So yeah, I think we will close the online session for the day and again resume tomorrow. Tomorrow morning India time. Thanks, Professor Zeleznikow.
Pleasure.